platform, you are all welcome. The agenda was circulated. Let's start with, are there any apologies?
Good morning, Chair. We have got an apology of Mr. Swart.
Okay, thank you. That apology will be noted. Let's go to the second item, the report on the land court bill. Who is iPhone? Who is iPhone?
Thank you, Honorable Chairperson. It's the National Commissioner of DCS, Samuel Tubakale. I'm trying to name myself, Honorable Chairperson. I'm just failing a bit technologically. I wanted to apologize for that. It is me, Tubakale.
Okay, no problem, Commissioner. Thank you very much.
Thank you, Chairperson.
Thank you. Let's start with the report on the land court bill. Can you flight it? Thank you very much. The report was circulated and it's taken as read. Are there any corrections on page 1? Let's go down.
Chair, that's the report. It's just the paragraph.
Oh, okay. Any mover for the adoption of the report?
Chair.
Honorable
Good
Chair.
morning. Good morning and good morning, members. I was trying to put my hand. I just want to adopt the report as presented. Move for the adoption. Thank you, Chair.
Thank you very much. Any seconder to Honorable Secretary's move?
Honorable Mayor Druchen seconds the adoption of the report, Chair.
Thank you very much. Any objections? No objections.
Chair, the DI reserves its position.
The Democratic Alliance reserves its position.
Chair, the EFF would also like to reserve its position, if you don't mind.
Okay, EFF also reserves its position. The report is agreed to. So it will be sent to the NA for a debate and approval. Thank you very much. Thank you, members, for attendance and ensuring that we do have the necessary quorum to adopt the report. As we know, it's a Section 75 bill. If the National Assembly endorses the bill will go to the President for assent. We all know, members, that those who attended the Judiciary Day, there was some discussion and concern about the slow pace of approving this bill. So the bill finally would go to the National Assembly with the corrections or amendments that were done by the National Council of Provinces that we have agreed with. So from here on, it will go from the National Assembly to go to the President for assent. Thank you very much. Next item, Correctional Services Amendment Bill.
Good morning, Chairperson. Good morning, honorable members, National Commissioner and senior members of the department. I don't know, Chair, whether this is the cue for us to come in now that you refer to the amendment bill.
Yes, Deputy Minister, let me apologize. I did not see you. You are welcome, Deputy Minister Ulomisa. Yes,
thank you, sir.
The opportunity is yours.
Yes, Chairperson, the National Commissioner and his team are here, and we are here to brief the Portfolio Committee on the bill as has been agreed to by Cabinet and duly delivered to the Speaker and the National Chairman of the National Council of Provinces for his consideration by Parliament. The bill has been coming before the Portfolio Committee for quite some time now, and I believe that the members, honorable members, are familiar with what the bill is about. Basically, the aim is to implement the decision of the Western Cape High Court, which was endorsed by the Constitutional Court, to give effect to the meaningful independence of the Judicial Inspectorate for Correctional Services, where the JICS does not find itself having to account directly to the very organization or department that it is intended to monitor and oversee whether it complies with the requisite provisions of the law and the Constitution. So in our view, this has been effected by the by the crafting of the amendment bill to the Correctional Services Act. Of course, there is still to be a bill that is going to ensure that the JICS becomes an independent entity that is going to serve its purpose more meaningfully. But in order to give effect to the provisions, rather the directives of the Constitutional Court, the amendments have been effected so that we don't fall foul of failing to comply with the decisions of the Constitutional Court. So I shall hand over now to the department to give more detail as to how we are giving effect to that decision. Thank you very much.
Thank you, Deputy Minister.
Thank you, Honorable Chairperson, honorable members, and our Deputy Minister. Greetings. Honorable Chairperson and honorable members, as the Deputy Minister has indicated, we are presenting the draft bill as progress, and also we would like to request support from the Portfolio Committee in our endeavor to get the amendments through the required processes and to the point of finality. Honorable Chairperson, through you, I would like to request that we allow Mr. Jack van Wyk, who has been leading on the technical side in terms of this process, to make the presentation. Thank you, Honorable Chairperson.
Thank you, National Commissioner.
Good morning, Honorable Chair, honorable members, Honorable Deputy Minister, National Commissioner, and members of Correctional Services and JICS, and I see Opsla is also here. Thank you for this opportunity to present. I think enough has been said regarding the background and where this bill originates from the Somke Gender Justice NPC judgment in the Constitutional Court. If you allow, I will go straight to slide number 5, which talks about the actual sections intended to be amended. Firstly, we intend to insert certain new definitions in section 1 of the Correctional Services Act, the CSA. First one being that of remand detention facility, as various sections in the Principal Act makes mention of this terminology or this position, but it's not reflected in the definitions in section 1. Then further to that, also to insert sexual violations and torture and the meaning thereof in the context, especially with regards to the new proposed Section 95B concerning the mandatory reporting obligations by the department to JICS. So that is the reasoning behind inserting those definitions. Then we move to sections 30 and 31 concerning segregation and restraints. The aim is basically to insert provisions that inmates must be informed of their right to appeal against being subjected to segregation and restraints, and this must be reported to the inspecting judge, or that they've got an appeal and that they can lodge this appeal to the inspecting judge. And that the head of the correctional center or remand detention facility must provide all relevant information relating to the appeal process on segregation and restraints to the inspecting judge within a period of 24 hours from being requested to do so. These provisions are included in the bill to strengthen the cooperation between the department and JICS and to enhance the independence of JICS, to ensure greater transparency, to strengthen the human rights of inmates, and to comply with ratified international instruments and law, such as, for example, the Mandela Rules. Then we move on to Section 88A, capital A, concerning the issues of the CEO of JICS. One of the sections the impugned sections that have been found wanting and declared defective, Section 1B, currently says that the CEO is accountable to the National Commissioner for monies received. In principle, this subsection we submit needs to be deleted, and it will be basically replaced by the provisions that I will touch on later in the amendment to Section 91. Then to amend the appointment of the CEO, currently it says the National Commissioner. Currently it says the National Commissioner, but to change it to the Minister. In other words, the Minister of Correctional Services performs the appointment or approves the appointment of the CEO of JICS. Then to add the wordings of career incidents under the control and management of the CEO in subsection 3. And then matters related to the misconduct in the capacity of the CEO to be considered by the inspecting judge and referred to the Minister, and that the National Commissioner has no role forthwith to play. Then to Section 91, you will recall that this was the second section or the other section that was declared unconstitutional by the Constitutional Court in Sonke. Currently, it says that the department shall be responsible for the expense of JICS, but the intention is to amend it. Firstly, to indicate or to provide that the expenses of JICS or monies will be defrayed, or the expenses will be defrayed from monies appropriated by Parliament to the departmental vote in terms of the Public Finance Management Act, and that these proposed amendments to Section 91 includes the issues surrounding the CEO to be the accounting officer in terms of the Public Finance Management Act, and the duties that are summarized with regards to the CEO. Then we can just mention, if we look at slide 9, that both ministers of DPS and finance supports that JICS be established as a separate government component, and that the Minister of Finance supports the provisions amending Section 91 in this bill. We can just mention, as it is quite relevant to the whole process, that the request for the establishment of JICS as a separate government component will be tabled together with the new JICS bill as soon as the budgetary issues concerning JICS have been resolved with Treasury. The last note that we have is that there are still engagements between the department and JICS and National Treasury regarding this. As soon as that is concluded, then we can launch those two parallel processes. Then moving on to the last section, we envisage to amend section 95D, concerns the mandatory reporting obligations of the department to JICS. This will be also in furtherance and compliance with ratified international instruments and law. The Mandela rules, obviously also the Sonke matter or Sonke judgment or Sonke case, and importantly will bolster the public's perception of the cooperation between DCS and JICS and the latter's independence. We can then also move on to slide number 11 concerning the compliance, just briefly. As alluded to by Honourable Deputy Minister, that Cabinet approved that the bill may be introduced into Parliament. It was approved by Cabinet on the 10th of May 2023. The Office of the Chief State Law Advisor issued a final certificate on the 19th of May on the constitutionality of the bill and found it to be properly drafted in the form and style which conforms to legislative practice. Further to this, the department complied with Rule 276 of the Rules of the National Assembly. And as is mentioned there, it was also then published, the notice was published together with explanatory summary in the Government Gazette on the 26th of May 2023. And then lastly, the department also complied or is complying with Rule 159 of the Joint Rules of Parliament, in that the ministerial letters were submitted, as alluded to also by our Honourable Deputy Minister, to the Speaker of the National Assembly and the Chairperson of the National Council of Provinces, together with the final proof of the CSA bill and the memorandum of objects. We then submit, Honourable Chair, Honourable Members, that it's recommended that the Portfolio Committee notes the progress in implementing the Constitutional Court judgment in Sonke, and that the Portfolio Committee will support the introduction of the bill into Parliament in accordance with Rule 159 of the Joint Rules of Parliament for the Correctional Services Act 99. That is the end of our presentation. I thank you.
Thank you very much. Deputy Minister, do you want to say something before we move to JICS? Yeah.
No, Chair, I don't have anything to add except to request the support of this bill by the Portfolio Committee.
Okay. I think before I give opportunity to members to ask questions or make comments, JICS.
Honorable Chair, good morning to you and good morning to all our esteemed members of the Portfolio Committee. Our humble greetings to our Honorable Deputy Minister and to the National Commissioner present on the platform, and to all those that are present here. I tender the apology of our inspecting judge who is committed with other official business. We actually support the introduction of the Correctional Services Amendment Bill. This has been extensively canvassed and discussed both with JICS and the National Commissioner's Office, together with representations from the Ministry and the Deputy Minister's Office. We confirm the submissions made by my esteemed colleague, Mr. Van Wyk, with regards to the finalization of the discussions on the funding that's currently in its advanced stage with the department, together with National Treasury, and we hope to have this finalized very soon, Honorable Chair, honorable members, so that we could introduce what we would call the two pending cab memos, and that is the one on JICS draft bill and also constituting JICS as a national government component. from JIG side, we support the submissions made by my esteemed colleague, Mr. Van Wyk, through the Office of the National Commissioner. Thank you, Honorable Chair. Thank you, members.
Thank you very much, members. Any comments? Honorable Nieuwort Droegen.
Good morning, Chairperson, and thank you very much, and good morning to everyone on the platform. Just for clarity, I wanted to make sure that I'm understanding it correctly. On slide 11, under compliance, it says Cabinet approved that the bill may be introduced. Now, I just want to make sure which bill are they referring to here? Is it the JIGS bill? Or is it the Correctional Services Amendment Bill? I just wanted clarity on that. My understanding of this, the reason why I'm asking for clarity on this is to just make sure if the department is making amendments to the Correctional Services Bill or the Correctional Services Act, so then, you know, why do we need a separate bill? I just need clarity. So I just firstly wanted to make sure whether this bill referred to in the presentation, which bill it is. So just that clarity, just to understand it better. Thanks, Chair.
Thank you very much. Honorable Maseko Jele.
Thank you very much, Chair, and good morning to DM and the team. Chair, I only have a comment on this one. Is about we welcome the presentation. We also welcome the changes that the department has come up with in line with the decision of the court. But I wanted to comment, Chair, that it will be important for the department, whilst we give our inmates the rights that they deserve, that the people who will be implementing and also taking care of those rights, and also making sure that those inmates, they receive their rights accordingly, Chair. But also, in fact, also JIG, including JIG, Chair, because is that, Chair, they must consider also, it shouldn't be only the rights, they must also consider the limitations on those rights, because some of the things that are happening in terms of dispatching of these rights, they sometimes outside, when people are looking outside, they make comments, many comments. We all know that they are saying going to a correctional service, it's like you're going to a hotel. So it's those comments that will make people feel like the government is just not taking care of the victims, only caring about the inmates, the perpetrators. So it was just a comment to say in implementing these rights, we must also consider the victims, Chair. And also the independent of the JIGs, they must also assist. They should not just, you know, in their independence, Chair, they must also consider that they are also assisting us in building this nation, in making sure that we get to the democracy that we envisage fully. Thank you, Chair.
Thank you, Honorable Yako.
Enkos Kakhulu, Chair. I think what I would, I think also I have a comment. However, mine is a bit different from Honorable Maseko Jele, in that I just hope that, you know, with this bill being passed, that you know, there are prisoners who get into the prison system sometimes, not because they are innately criminal in their conduct, maybe whatever circumstances that they may come into. I just hope that, however, if we pass this, and when we pass this, that whatever that we say is going to happen and is going to trickle down to actual work in the prison system, and that we protect those who are vulnerable, because we do have vulnerable prisoners who come into the system and then find themselves participating in things that they should not have otherwise participated in because of the environment that they're in. So I do hope that this protects the prisoner also, in as much as it does protect the victims of the prisoner. Yes, I understand that. But I've noticed that in the correctional service space, there's very little that is done to really protect the prisoner, as if one is uniform across. And sometimes the crime is not the same across the board, but we lump them all together. And that then perpetuates a system where we encourage more criminality happening, or behaviors that play into that space. So it's just a comment to say that I do hope that we strive to protect those who are vulnerable in the space of correctional service. Thank you, Chair.
Thank you, Honorable Horn.
Thank you, Chair, and good morning to all colleagues and the representatives from the department and the Deputy Minister. Chair, apologies if this has been covered. I was well connected offline for a minute or two. My question is on the proposal around specifically addressing the finding that the institutional independence of JICs is not sufficiently or constitutionally protected by the way currently the appointment, amongst others, of the CEO is handled. And the proposal is then to move it now from a appointment authority resting with the National Commissioner to the Minister. And I don't know to what extent the department has considered whether that specific move addresses the issue, if at all. As it is now, the National Commissioner is the accounting authority of the department, and the Minister is the executive authority. And if one talks about independence, real independence could obviously only be achieved if the appointment is moved outside the domain of the executive. I don't know whether to move it from the National Commissioner to the Minister makes much of a difference. And I don't know to what extent other models have been looked at. For example, whether the inspecting judge, whether it has been considered that the inspecting judge could have a role to play, given the fact that if one talks about an independent judicial inspectorate, the inspecting judge ultimately will be more than just let's say, the operational head in terms of leading the operations from a perspective other than administrative issues and administrative operations. So I have a bit of a concern that this specific proposal will not necessarily fix the unconstitutionality, and I don't know whether this has been considered to strengthen the independence through not only involving the executive in the appointment of the CEO. Thanks.
Thank you. Deputy Minister or anyone from your team?
May I request that the department responds first, Chair, and then I'll come afterwards.
No, that's fine.
Thank you, Honorable Chairperson, and thank you, Deputy Minister and honorable members. Chair, I just wanted to talk to the 2 points that were raised by Honorable Nivot Drachen and also Honorable Masiko Chele and Honorable Leako, just to indicate that one of the points that we mentioned with the introduction of the draft bill is that it also aims to strengthen relations between GICS and the department, thus ensuring that GICS assumes its responsibility to the fullest and deals with issues from an independent platform with no interference. And just to confirm, Honorable Chairperson and honorable members, that we are also concerned about the safety and the conditions that are conducive for our members to do their work, given the dangerous nature of the environment that they are exposed to on a daily basis. But also, we are also gravely concerned about the treatment of offenders, especially in the context of what was mentioned by Honorable Leako, that we aim to strengthen our reclassification or classification processes so that offenders are classified properly and they are accommodated in units or correctional facilities that would not worsen their conditions, but also that would not create conditions that are not conducive for rehabilitation and correctional programs to be implemented. Having said that, Honorable Chairperson and honorable members, I will then request Stefan Veig to provide responses to other technical questions that were asked. Safe to say that the removal of the participation or the determination of the National Commissioner on the appointment of the CEO of GICS and vesting that in the authority of the minister, in our view, creates a balance in terms of building those good relations, but ensuring that there is a cooperation between the executive and GICS itself as an entity created through the Correctional Services Act. We do not necessarily see that as further eroding the independence of GICS, and we do not necessarily see that as putting a damper on us complying with the constitutional court judgment. As I've requested, Honorable Chairperson, I would like to repeat again and request that Mr. Van Veek be given an opportunity to then respond to the technical questions. Thank you, Honorable Chairperson.
Thank you. Mr. Van Veek.
Thank you, Honorable Chairperson. Thank you, National Commissioner.
Sorry, Mr. Van Veek, before you proceed, who is Galaxy A21S? Galaxy A21S. Committee Secretary, can you check that? Proceed, Mr. Van Veek.
Thank you, Honorable Chair. To respond and reply to the two questions, thank you so much. The first question concerning which bill slide 11 refers to in the first bullet, it is the Correctional Service Amendment Bill. It is the bill that has been taken through all the processes, commencing from the NCCS, OXLA, DEFCOM, etc., until it reached Cabinet, to amend in the main the impugned sections as found by the Constitutional Court. The Constitutional Court found Section 88, capital A, 1B, and Section 91 to be unconstitutional. So the main aim of this bill is to correct those defects. And this is done by the CSA bill. I can just mention, as we've discussed previously in our previous submissions and briefings of the Portfolio Committee, the Sonke matter started in 2017, January. And at the time, there were a lot of discussions between various departments and the presidency as to how to deal with this matter. And the idea from that time, long before there was a judgment in this matter, either in the Western Cape High Court, then later on in the Constitutional Court, was for JICS to have a separate bill, a separate act, and also to be constituted as a separate government entity or component. Hence, in roughly 2019, JICS, in conjunction with the department, started to develop, JICS developed a business case for such establishment, and also commenced with the drafting of a JICS bill. A lot of interaction took place between the department and JICS to such an extent that we reached a version 20 of the JICS bill, but of the fact that we awaited final determination from and support from National Treasury regarding the establishment of JICS as a government component, and in light of the fact that time was running out to comply with the Constitutional Court order, which was initially due December last year, the 4th, and it necessitated us to apply for an extension till 3rd of December this year. The decision was taken and was well supported for the Correctional Service Amendment Bill to be utilized to comply with the Constitutional Court judgment. This, however, does not mean, and as I've discussed in our presentation, that the JICS bill is shelved or parked. It will definitely run its course. It will ultimately repeal all relevant sections in the Correctional Service Act concerning JICS. It will make provision for the establishment of JICS as a separate government component. And as soon as the budgetary issues have been resolved and finalized and approved with National Treasury, that process will commence in all earnestly. So that is the actual, that was the actual plan from the start, that the JICS bill would invariably be used to cure any defects the court might have found in the Act concerning the independence or lack thereof of JICS. But unfortunately, with regards to outstanding issues beyond the control of the department and JICS, it necessitated the introduction of this bill. So I hope that that addresses that concern. It also links up with the second question from Honorable Mr. Horn concerning the question or the concern raised that to change the authority or the appointment authority of the CEO from the National Commission to the Minister. We support, well, I want to echo what our National Commissioner has said, that we are of the view, and it's also well supported by JICS and also by Oxla in their legal opinions, that it will not be a hindrance or detract from the importance of JICS to be more independent or institutionally independent, should that be the case. And for practical purposes, that would be the way, the only way to achieve that goal. Because if one recalls, the two sections, as I've mentioned, 88A1B and 91 of the Act was found unconstitutional or found wanting. And if one looks at that, the CEO is accountable in section 88A1B, is accountable to the National Commissioner for monies received. Now that's being deleted and it's replaced by the provisions in section 91, which is the other section found in that it basically says that the department will not be responsible for the expenses of JICS, but it will be defrayed. Expenses will be defrayed from monies appropriated by Parliament in terms of the relevant legislation. and ultimately for the CEO to be the accounting officer in terms of the monies received. So that addresses that. We are of the view that that addresses that. And also further to that, in section 88A, we went further than what the court actually requested. And we also amended other subsections in section 88A, capital A, wherein we said that when it comes to with regards to the misconduct and incapacity or any conduct of the CEO, that it's no more for the national commissioner, for the national commissioner to be involved in that process, but that it will be considered by the inspecting judge and referred to the minister. And hence also that appointment of the CEO lies with the minister, as it's an administrative decision, and the inspecting judge is not responsible, is not really ends at jigs to be involved in administrative functions. So that's basically the reason why it's been couched like that, why it's proposed like that, and it's been extensively deliberated to that such a thing. So we submit, and for these questions and concerns raised, we fully take note of that. But yes, we submit. Those are our responses. We thank you. Thank you, Mr. Chair.
Thank you very much, Mr. Van Wyk. Substantively, how can you say that you have really moved, except that a bill has been introduced? How, in fact, what you are doing now, how is it substantively different from the position you were in before we went to court to ask for an extension? Because my understanding was that it was always easy to deal with the issue of this bill, but the issue was always with the National Treasury coming to the party. They have not. So now, with all these months or years that have gone by, how are you substantively in a better position than you were before?
Thank you, Honourable Chair. Through you and on behalf of the National Commissioner, if I may, with regards to the issue of Treasury, the main issue that prevented us from introducing the bill timeously before we applied for extension was for Treasury to recommend and endorse that the JICS be established as a separate government component. At the time, it was not about budgetary constraints as it is now. The main issue was that we needed, as is requested and required by Section 7 and 7 capital A of the Public Service Act, we need the support and recommendation from both ministers of DPSA and Finance regarding the establishment of the government component, or JICS as a government component. Now, this has a profound impact on specifically the provisions or the proposed amended position or provisions in Section 91 concerning the CEO as the accounting officer. Now, let's put it this way. Whilst we were waiting for Treasury to indicate whether they support for JICS to be constituted or established as a separate government component, we had to, whilst we were waiting for that, we could not include in this bill for the CEO to be the accounting officer because of the provisions of Section 36 of the Public Finance Management Act, which clearly states that the CEO in this instance cannot be the accounting officer if JICS is not a national department, a constitutional institution, or a separate government component. So that hindered us from inserting that into the current version of the proposed amendment bill. And that is the reason why we cannot take that any further. And it was also highlighted and supported by Oxla at the time, and also by DEFCON, and also by the meeting with the JCPS cluster DGs last year. So that was what was outstanding, Honorable Chair, at the time. And then during this year, I think it was around February, we finally received the recommendation or the endorsement from the Minister of Finance that they support for GICS to be established as a separate government component. And this then triggered us, and this assisted us then to finalize the processes with regards to this current bill, and so that we could have the provisions that we currently have to take it forward. Unfortunately, in brief, we could not submit the current version of the bill last year without, in terms of Section 7 and Section 7A, capital A of the Public Service Act, we could not submit such a bill without the support and endorsement from the Minister of Finance. I hope that answers your question, Honorable Chair. Thank you.
Thank you very much. At the last one, operationally, this amendment without the GICS bill, does it move anything? Does it make any difference? Mr. Van Wyk.
Thank you, Honorable Chair. Yes, I was just writing down your question so that I don't forget. Age is not a good thing. Anyway, yes, with regards to, if I catch it correctly, you say, will this bill take anything further without the GICS bill? With regards to this bill and the intention to amend certain provisions of the Act, it would then, and also as supported by the Office of the Chief State Law Advisor, and also supported by GICS, that this will assist or ensure that there's compliance with the Constitutional Court judgment, seeing that we have time constraints with that. Then further to that, the purpose of the GICS bill is to culminate what was envisaged a number of years ago with regards to GICS and the total independence. Well, not total independence, as the Constitutional Court also alluded to, that there's no such thing as absolute independence, but at least such independence, institutionally and otherwise, for GICS to function with its own budget without being dependent on the same department it's actually overseeing, and that will be fulfilled by the GICS bill. But the GICS bill in nature is, as I said earlier, is at version 20. If I can recall correctly, it's about 34 pages. That goes hand in hand with the establishment of GICS as a government component. And we were of the view, and it was also well supported by other role players, that if we prefer to only use that bill to take it through these processes and ultimately to introduce it into Parliament, because remember that bill has not gone through the first phases at all, such as the NCCS in principle, in light of the current developments with regards to National Treasury, etc., presentation to DEFCON, presentation to JCPS cluster, DGs and ministers, etc. So that would have not assisted in timeously complying with the Constitutional Court deadline. So it was plainly the only purpose of the Correctional Service Amendment Bill is to address the concerns of the Constitutional Court timeously without having to the extension in this regard. But in saying this, that as alluded to earlier, that the GICS bill will be forwarded and will be tabled and go through its processes as soon as the issues regarding the physical budgetary issues, in other words, how much finance or treasury is willing to approve as the budget for GICS in them being established as a separate government component. So that is in principle what this process is about, and to ensure that that we comply, that Parliament complies with the Constitutional Court judgment. Thank you, Chair.
Thank you. So, Deputy Minister, will we be correct to say the GICS bill will not be dealt with this year or in this administration?
Yes, Chairperson, you are correct, considering the amount of time that it has taken us for this particular one to be coming to this stage that it is at now. And also importantly, we shall have, well, Parliament shall have enough space now without the pressure coming from the Constitutional Court's directive that it be passed within a particular period of time. So there will be enough time to do all the consultation that is necessary, because we have seen that it involves a lot of other departments like PSA, Treasury, ourselves, of course, and other interested parties. So we believe, therefore, that the time that we'll have will be enough for us to ensure that we're putting up a bill that is relatively going to be permanent in terms of setting up the structures that are required. Perhaps, without directing you on how to conduct a meeting, it might be helpful to this meeting to have Mr. Misa, the CEO of GICS, responding perhaps to the question asked by yourself and also by Honorable Horn, as to how effectively is it giving independence to GICS, the fact that the minister still has the role that he has to play, especially in the appointment and disciplining of the CEO.
No, thank you very much, Deputy Minister. I think it's a fair request. CEO GICS.
Honorable Chair, thank you so much, honorable members. Yes, thank you, DM, for the opportunity to reflect and comment. I think, yes, I think the aspect of the appointment, the disciplinating of the CEO, I think it's well canvassed in the amendments in terms of Section 88A, where the inspecting judge plays an active role in ensuring all those processes are dealt with and thereafter referred to the Honorable Minister for consideration, either on appointment or either taking the necessary steps on disciplinating the incumbent in that position, the CEO. I think that aspect is covered, Honorable Chair, honorable members. I think the aspect that worries me is the issue of the appointment of the CEO per this submission as the accounting officer. And that is canvassed in substitution of Section 91, sub 3, where the chief executive officer as the accounting officer of the judicial inspectorate must, subject to the public finance management, be charged with the responsibility. Now, honorable chair, honorable members, if GICS is not yet constituted as our honorable member puts it, honorable member Horn, institutional independence, if GICS is not constituted as what we would call as a national government component, which we're punting for, and which has already been agreed and passed through the Interdepartmental Assessment Committee, recommended by the Minister of DPSA and seconded by National Treasury, it would be virtually impossible to have this specific section, the CEO to be the accounting officer, if that has not been dealt with, because we cannot have two accounting officers in one department, and that is the clash. I think that is the biggest hurdle that we need to pass here. So I think where we need to step back, we need to ensure that GICS is constituted as a national government component with its necessary funding, which secures and insulates its institutional independence and gives it all the operational requirements that it requires in order for it to act independently and to perform its functions as a watchdog to that of the very same department we are talking of. So I think this is what might be a hurdle that we need to cross very soon in order for us to really take this Correctional Services Amendment Bill forward. I think this is my reflections on it, Honorable Chair. I might be subjected to correction. Thank you.
Thank you very much. The National Commissioner has lost sound. I hope he will be assisted to join as soon as possible. So, CEO, what do you suggest needs to be done? Because from after today, the bill will be out for public comments. And then when we come back from recess, then we will start with the public hearings. So between now and then, what do you suggest needs to be done to deal with the issue that you are raising?
Honorable Chair, thank you once again for the opportunity. I think upfront, this bill has been extensively debated with the inspecting judge and the colleagues from JIGS, together with the ministry, as I've already alluded to. I think we support the Correctional Services Amendment Bill because it's in line with what we would call the Sonke judgment and that of Constitutional Court. The only hurdle, as I say, is that we need to ensure that JIGS is constituted as a national government component. That is the biggest hurdle. Once that has been dealt with, obviously, we can then move into what we would call the JIGS draft bill, and then which runs parallel, and also to deal with appointing the incumbent or the CEO as the accounting officer, separating that from the department itself. I think at this point in time, there is a clash. This is my submission.
Members, can I suggest that the Deputy Minister takes up the matter with the Minister of Correctional Services? Because I think it's more of an administrative and executive issue that needs to be dealt with, that they ensure that this government components, JIGS as a government component, is established as soon as possible, that the Minister, our Minister, Deputy Minister, engages with National Treasury and all relevant bodies that would ensure that it is established as soon as possible, so that when the bill is passed, we don't have to deal with this hurdle.
No, it's fine, Chair.
Yes, Chair.
Thank you. Deputy Minister.
Oh, thank you very much, Chairperson. Well, I'll take the directive that the Chairperson is giving, that I engage the Minister about this very particular matter. The committee must be aware that, as Mr. Misa has said, that a lot of engagement has taken place involving all relevant stakeholders, including the parliamentary legal advisors. Everybody has agreed that this bill complies with the directive of the Constitutional Court. But there's a bill that has been drafted, as has been said, the JIGS bill, that is going to, in my view, take care of any other issues that relate to the practical independence manifesting itself of the JIGS body. So I think, therefore, that we will engage with the Minister and other people, but we wouldn't want that that results in a delay in the passage of this bill, as everybody agrees that it is in compliance with the Constitutional Court decision. So, in other words, I think the arguments that have been proffered by all sorts of people from all sides are likely to be rehashed until there's another mechanism that is going to deal with that. Which means, therefore, that if we were to make sure that I think agree to the other process, which revolves around the JIGS bill, because the JIGS bill, as I repeat myself, is going to take care of any other snacks that have been left hanging because of our rush to ensure that the amendments in accordance with the constitutional directive are implemented. I don't know if I may proceed to other issues that I wanted to comment on, Chair.
You can comment, dear.
Well, there's a matter, the two matters raised by Honorable Maseko Jele and Honorable Yako. There are policy issues that ought to be addressed by this portfolio committee at some stage. The perception that offenders or inmates are pampered in our centers, it has to be addressed, because it's a constitutional imperative that we treat inmates or offenders as human beings, that we provide them with all the necessities that are necessary to be provided to persons who are no longer in a position to fend for themselves. And we have the Mandela rules and other international protocols that we are subjected to, which require that inmates must come out better people than what they were, which means therefore that we have a responsibility as DCS to ensure that they get the skills that are necessary in the education that is necessary for them to be able to fend for themselves and to become better and decent citizens than they were before they came, when they came into our centers. Now, the matter of the victims, we always say when we try to address this, is really not the responsibility of the Department of Correctional Services beyond ensuring that these people are kept in our centers in accordance with the judgment and decisions of the court, and that they are kept secure and that they are looked after properly. Beyond that, the question of the victims now is a matter that is subject to our justice administration system. As honorable members know, our justice administration system is costly when it comes to the compensation for victims of crime. They have essentially to go to lawyers and institute civil proceedings in order to get recourse on a personal basis, because the state is concerned with the criminal aspect of what has been done, the breaking of the law. But the question of compensation for the victims is something else. It has to be dealt with in a different way. In criminal matters, the victim is defended, or the interests of the victim are looked after by the prosecution. But in terms of the civil rights that the civil actions that they have to institute, then they have to hire lawyers. I know that you have the legal aid and so on. And there's also a provision in the Criminal Procedure Act about the court having the right to take a decision on what compensation can be given. But in general, if you want to be compensated properly as a victim of crime, you need to go via the civil court route. So, but we should also consider, as this portfolio committee, I think I've raised this before, that we have a discussion with other departments like social development and see what it is that can be done, something equivalent to the benefits that are being enjoyed by the offenders in our centers for the victims. It doesn't sit well for a victim to find an offender moving around the village with skills that the victims were not in a position to acquire, principally because their breadwinner or the person they depended on was killed by the very same offender, who is now in a position to even hire the relatives or even the victims of their crime. So something needs to be done. And I know that generally we inherited a system as a country which did not take care of victims in the same way as the criminals are being dealt with. As I say, because they have to buy the services of lawyers in order to get the justice that they need. But you have an obligation as DCS Honorable Maseko Jele to look after the people that have been placed in our care to the best of our ability and in accordance with international obligations that we are subjected to. Thank you very much.
Thank you very much, dear. I think that was the last speaker on this matter. I propose that this committee secretariat, I think in order to save costs, because we have just given a green light for the invitations for adverts, in fact, for adverts for commissioners, also Human Rights Commission, that that in order to really save cost, if this advert can go as one, so that we don't issue this advert this week and then the other one next week, I think it will be also be good to give Parliament with its purchasing power a room to be able to negotiate, because we are bringing quite a number of adverts that we manage it in that way. Members, can we step out of this matter, but with the understanding that this bill is going to be allowed to go out for public comments, and then we will, when we come back, then we'll start processing the bill. Will that be in order?
Yes, Chair.
Yes, Chair.
Thank you very much, Deputy Minister, and to your team, National Commissioner, and everybody else. Jigs, thank you very much for your presentations and for your inputs. You are now excused.
Thank you, sir.
Thank you, Honorable Chair. Thank you, members. Bye-bye.
Thank you very much. Members, can I just, I think it will be a quick one. We have a proposed program that was circulated by Bonani for the remainder of the term. Have all members received it? It says the list of meetings, committee meetings. Have we all received it? Or we can flight it, yes. This is the proposed program for the remainder of this week and next week. Are we fine with the proposed program, members?
Yes, Chair. We are fine. I am.
Yes. Can I suggest just one addition on the 14th? Honorable Breitenbach, remember we've always had that that you would come and brief us on your on the NPA, on your experiences as a prosecutor and all of those things. And it's something that we resolved on it in 2020, and we have not been able to program it. And given the meeting that we had with Professor Morton, that it will nicely fit in your, and then that you wrap up and you have that a briefing also by yourself on the 14th. Would you be ready, or would you be ready for that?
Honourable Chair, yes, I'm happy to do it if the members are interested in doing it. It's fine. I'm quite happy to do it. I must say that I had a conversation with Professor Munting the other day. They were the victims of fiscal dumping, and so they got quite a big donation. And he asked if we would be interested in doing a series of smaller workshops on focused subject matter. And I said, I'm sure we would be. So he's going to put something together and then he'll approach you.
Okay, let's deal with it when there's that proposal. The members can be able to apply themselves to something written down.
Yeah, that's fine. But I'm happy to do the briefing if anyone's interested in it. That's fine.
Yes, thank you. I think it will conclude also that that workshop we had with Professor Manting and his team. Honorable Nevot Trochen.
Thank you, Chairperson. I don't see any approval of minutes of the past meetings.
Yeah.
I don't want it to carry
Yeah.
over to the next term. So if we can also look at the minutes, thanks.
Oh, that's very important. That's very important. Can we deal, I think on the, let's check on Tuesday.
Can you unpin Honorable Neo Druchen, please? Sorry,
Yes.
Chair.
Can we go back to the program? In fact, what Honorable Nevot Druchen has raised is very important, especially if we are going to be dealing with the issue of the study tour. We must have everything on our side being complied with, and they like to check the issue of minutes. And I think it would also be important that we approve the report of the last oversight visit. That was on in the oversight visit in Northern Cape and Northwest. If we can have that a report on our side, we must approve it, so that I think they will be debated when we come back in the House. All of them be debated when you come back. So we can have public hearings. I don't think these public hearings are going to take the whole a long time, the whole day. So we can have the public hearings, adoption of minutes, and adoption of, and then maybe before we start with Honorable Breitenbach on the 14th, then we have that adoption of the oversight program. And then on the 13th, I think you're right, on the 13th, we will deal with the minutes. And then on the 14th, we also deal with the oversight program. Will that be in order?
Yes, Chair.
Yes, Chair.
Then there is a possibility that around that day, the 14th, it might be a physical meeting, because I suspect that we will be debating next week. We'll be debating the Land Court Bill in Parliament, and that NCCS reports, I think it will be dealt with in Parliament. So we would be in Cape Town. So I think let's prepare that meeting would be physical, because it will be more of an in-house meeting. Because everything we'll be dealing with is more in-house, so, and it will be our last meeting. Any objections to that? None. Thank you, members. That brings us to the end of the meeting. We'll meet tomorrow at 9:30, briefing by the Department of Justice and Constitutional Development on the amendments to the practical guidelines for employees submitted in terms of Section 10(4)(b) of the Protected Disclosure Act of 2000. So we will just be dealing with that tomorrow. It will not be a long meeting. The meeting is adjourned.
Thank you, Chair.
Thank you.
Thank you, Chair.
Thank you.
Recording stopped.